People v. Hemingway.
Good afternoon. My name is Mark Schneider. I represent Carissa Hemingway. In this case, the law is clear and unambiguous. Criminal Procedure Law 200.50, Section 7 requires an indictment, quote, contain a plain and concise factual statement in each count.
So let's assume, counsel over here, so let's assume for one moment that it is a typographical error, right? It should have cited a different provision, okay? Does that fall under subparagraph 1 or 2?
If it's a typographical error that is not...
Everything else stays the same of what happened here.
I'm sorry?
Everything else stays the same as what happened here.
Yeah.
Right, the ADA is arguing or presenting to the grand jury their case based on drugs, not alcohol. There's no dispute about that. So does a pure typographical error regarding which statute you're referring to, does that fit under subparagraph 1 or 2?
It depends what the error is to. If it's a name or a place or a time.
The number of the statute.
Number of the statute, there's never been a case where the number of the statute has been found to not be substantive. Because
it's always subparagraph 2.
It's always 2. And in this case, perhaps if count 1 had said intoxicated by drugs and then cited the wrong statute, perhaps that would have met muster.
Counsel, the language of the actual statute that's being violated is accurate, right? Aggravated driving while intoxicated with a child is the language right out of 1192 2AB, right?
Yes.
So that's correct.
Well, intoxicated, though, normally means
that is
alcohol.
The title of the statute that they're charging. I looked at it.
Yes.
1192 2A
Yeah.
sub B is titled in its entirety, even though it applies to different subdivisions, aggravated driving while intoxicated with a child passenger.
Yeah.
So that's accurate.
Yes.
What is not accurate is the committed as follows paragraph where they cite subdivision 2 twice, right?
Yes.
In the cases I've seen, and maybe there are others you can point me to, where it's a subdivision error, where it's a number error, I think you were just discussing with Judge Rivera, it seemed like there was descriptive words around that number. So if, in this case, it would have said driving while in violation of driving while intoxicated under subdivision 2 of 1192, I think that's very clear. That's wrong, right? But here, there's no description in that part. There's no description of driving while intoxicated or driving under the influence. There's just a number, which makes this a little bit different than the cases that I've seen, where you cite a wrong statute, but the language surrounding the cite is also wrong. And here you don't have that.
Well, but here, again, let me finish what I started out saying. 200.57 requires an indictment have a plain and concise factual statement in each count which asserts facts supporting every element of the offense charged and the defendant against the defendant. In this case, if it had said drugs, but it's interesting
But it
here.
doesn't say anything. It just has a number.
Right.
So it's not that it's an affirmative error saying under the influence of alcohol, subsection 2. It says nothing. It just says subsection 2. And doesn't
Right.
that make it more, a better argument at least, that it's a typographical error in the number than it's a mischarge?
But it doesn't make a difference whether it's a typographical error or not. If it does, there are no facts to support count 1.
What about the facts given to the grand jury? If they were given to the grand jury, does
Well,
that matter?
Actually, yes, it supports my client's claim because the grand jury was not charged within count one. The ADA charged them saying drugs.
Because
then-
because the theory of the case was drugs, and the grand jury was charged that way.
Right.
But the indictment does not reflect the true bill voted by the
Correct.
grand jury.
That's
So
correct.
why can't the people conform to what the grand jury actually voted by changing the 2 to the 4? And it
Because-
doesn't, I don't think you're alleging that there's any prejudice to your client.
We're not saying there was prejudice, and we're not saying there was a change in theory.
Right.
We're saying the law is the law, and Section 272 says
So
an
you say that
indictment may
there's no-
not be amended.
Errors cannot be corrected. Is that your claim?
Yes.
But that's not what 270 says, right? They said you can amend as to errors of form and the like. Why isn't this either form or the like?
Because it's not, because there are no facts
What would
alleged.
an error of form be? Can you give me an
error-
example?
An error of form in this case would have been, instead of saying my client was driving a Mercury Mountaineer, that they were driving a Ford Mountaineer.
Why is that form?
Well, it's the wrong name of the vehicle. It's something that's non-substantive. But the actual statute itself that is being charged is substantive.
Well, time could be substantive,
Time can be
but
substantive.
yet amendments for time are allowed.
No, they're not. Not under Van Avery, and under Perez, if you have a time in the future that was specifically referenced by this court in Perez that you cannot amend to change if the time is wrong.
Well, that was because it was a future crime, and you're saying that you can't say something's going to happen in the future if it hasn't happened, but there can be amendments to time.
Sure.
As long as there's no prejudice
That-
that might impact an alibi or something like that.
But prejudice or changing the theory is not relevant or material under subsection 2 of 270. And the grand juror actually said that, oh, well, is intoxication mean drugs? And the ADA said, well, isn't that in there? And he said, the grand juror said no, and he said, I'll change it. And I will initial it and we'll change it. And they did not change it. And we have to follow Perez, we have to follow the laws.
So are you saying this is 2A or 2B or both?
2B.
Legal insufficiency of the factual allegations.
Right, I mean, yes, under 1292-2, that states a claim, but there are no facts to support it. That claim would be driving while intoxicated by alcohol.
So let's say they had put in the indictment in violation of subdivision 2, driving while under the influence of drugs, or whatever the language in there is. Let's say, hypothetical. Instead of this language, which just says operate a motor vehicle in violation of subdivision 2, you had the same thing, but they said in violation of subdivision 2 under the undue influence of drugs. They used the language from the right statute, subdivision.
We're talking about 1292 or 200.70?
Looking at count 1, right?
I'm
And
sorry?
the error, count 1, the error
Yes.
is, they say a motor vehicle in violation of subdivision 2 of 1192.
Yes.
Which is driving while intoxicated. And
Right.
what should be there is driving while ability impaired, right? By-
Number 4, that's
Right.
correct.
So what if it said a violation of subdivision 2, driving while ability impaired by drugs?
I think that could have passed muster, because then it says drugs, and then it's clearly a typo. But again, if we go back to the requirement, a plain and concise factual statement. But looking at it as it was written, we're not
Then let me
talking
just- Can I
policy.
just clarify that? Okay, so count 1 says aggravated driving while intoxicated with a child passenger, and then in describing how that is, it refers to subdivision 2 of section 1192. Are you saying that if that first paragraph says intoxicated with a child passenger, but the second paragraph had the correct reference, that is to say, now you've got an internal inconsistency, that would just be an error that could be corrected?
No, you can't bootstrap the second misdemeanor count into count
No,
one.
I'm still on count one. I'm not looking at the second count.
Yeah, okay, so we're looking at count one, and what's your hypothetical?
If it has language that says driving while intoxicated, but also has a correct reference to ability impaired, and in
By
fact may even
drugs.
say that, or say drugs. So you have this tension, right, this inconsistency. One is saying it's about intoxication based on alcohol, and the other one is referring to drugs. If you've got both working in the same count, would you say that's an error that could be corrected?
If it said drugs
Yes.
and paired by drugs, then
Even
that would
if
be
it
fine.
also incorrectly mentioned alcohol.
If it said both, as long as it said drugs
Drugs at
and
least.
impairment by drugs, and even if it left out 1292-4, the indictment doesn't have to have the section, it has to contain the facts. And the facts here, there is no fact that my client was intoxicated or impaired by drugs. And we're not talking about policy. This court discussed that in Perez. Under the common law, you could not amend an indictment for any reason. And then for non-substantive reasons, which doesn't change the facts, like if it had the wrong date that she was stopped, that would be non-substantive. If it had the age of the child as being a year instead of 6 months, that would be non-substantive. If it had, instead of Clinton County, if it said Essex or Franklin County, that would have been non-substantive. But here, adding the fact of drugs as a matter of law is error, and you should reverse and dismiss. And ADAs and district attorneys have to follow the law, and the law is clear here. They need to get the indictment right and state all the facts. And it's not a matter of policy. There are many things that are strict that may not seem fair. A statute of limitations, a 30-day appeal period, and people miss them. And it may not be perfect, but that's the law. And I think in this case, you have to follow Perez, which said that. The grand jury here knew about the drugs.
Yeah, but
they-
Perez was actually adding another different count. The CPW count wasn't there, and then they amended to add that, and we said you can't add a whole other count, which is very different, I think, than the situation here.
I disagree. Under 200.70, you cannot amend an indictment to correct a fact. Thank you.
Thank you.
Oh, did I reserve time?
No, but you haven't used all your time, so we'll give you a minute.
Well, I would like a few, yeah, I would reserve some time on rebuttal. Thank you.
May it please the court, Jamie Douthit for the people of the state of New York. Your honors, the trial court properly permitted a simple conforming amendment to an obvious typographical error, which in no way prejudiced the defendant. It merely provided the correct subdivision that was reflected in count 2 of the indictment, thus.
Count 1 is all about intoxication, not ability impaired by drugs, right?
Yes, but that is how the statute reads, as was pointed out.
Yes, but that provision is about alcohol. It's not about drugs. You
on
cannot violate
our-
that provision based on drugs. Have I misread it? Well, you can correct me if I'm wrong.
So, as charged under the law, Vehicle and Traffic Law, Section 1192 2AB,
Yes.
is titled aggravated driving while intoxicated with a child passenger.
Right.
But under that law, a violation of 1192 2, 3, 4, or 4A, all of those violates the law. It doesn't matter which one you violate, whether it's alcohol or drugs, as long as you have a child under the age of 15 in the car, then you're guilty of the offense. But it is titled intoxicated. It doesn't have It doesn't differentiate in the title of the statute whether it's alcohol or drugs.
So why
It's-
do we measure what the relevant offense is, as you're suggesting, as opposed to what the specific subsection is that is being referenced? In other words, I take it you're saying what we should look at as, well, let me ask the question. What's the relevant offense here?
The relevant offense here is driving while under the influence of drugs with a child under the age of 15 in the car.
Okay.
And what we have here is a mere typographical error as to which subdivision of the statute
Yes,
is actually
and so my
violated.
question is, your position, I think, is that the specific subdivision is not, you don't differentiate one offense from the other subdivision by subdivision, right? That it's all the same offense.
Correct.
Why is that the case?
Why is that the case?
Yeah.
Because I think I think the state is saying that if you violate any of the sections of the vehicle and traffic law and you have a child in the car, you're taking it from a misdemeanor to an elevated level of crime.
So even though it's different conduct, it would be the same offense, is your view?
Yes.
So that would go to your adversary's point, I think, that it's the factual part of your indictment that's lacking, because the way the defendant is supposed to have violated, which I agree with you, is aggravated driving while intoxicated with a child, but the only factual way he's alleged to have done that is by being under the influence, she's alleged to have done that as being under the influence of drugs, right? And there's no reference to that in your committed as follows section. So it's really more of a factual problem you have.
So I think, though, that as this court found in Iannone, that a factual issue can be cured by a bill of particulars. And in this case, no bill of particulars was actually, motion for a bill of particulars was made. So I don't think it's not a jurisdictional defect to not have allege all the facts. So I don't think that is, what we're looking at here.
Counsel, I'd like to go to something I think your adversary steered clear of, but is policy here. And here we are arguing about whether or not you meant 4 and you said 2, and why isn't a better rule like proof the indictment and then we wouldn't be here?
Well, then, so as counsel stated, under the common law, we couldn't amend the indictment at all. However, the legislature
No, I'm
did.
saying before you return it, it's a pretty big process, right? It's a felony indictment, you have a grand jury. Why isn't the better policy just make sure it's right?
Sure, but I think people make mistakes, and that's what happened here, and there is a CPL section that allows us
But are
to
they
make-
less likely to make a mistake if the consequences are you can't amend it?
But the law allows us to amend indictments.
Right.
I
That's what
understand.
we're going to decide, about whether or not you could amend this one. You're right about the amendments, that is true. But let me just go back to where I started, if you don't mind, because I think now I understand the point you were making about count 1. You are correct, of course, that it refers to 1192 2-AB, and that particular section doesn't say drugs or alcohol, but it does say that you have to fit under subdivision 2, 3, or 4, or 4A. And the only one that's referenced in the rest of count 1 is 2. That's, of course, what you say is the typographical error. But that's exactly what the count says. So the count is about alcohol. It's not about anything else.
So yes, but it, as I stated, it is a typographical error, which I believe that we are allowed to amend, and if there had been
So which category under subparagraph 1 does it fit? Is it form or is it the like?
I would say it's the like.
So how do we understand what the like means? How do we define that? That's what's hard about this case, I think.
So I think because the law is divided into subdivisions, that any of those subdivisions can violate the felony offense, I think that allows the amendment to be made in this case.
So if the statutory scheme had been just structured differently, it had the same content, but instead of subdivisions that were pulled into a different section of the VTL, you had these all in separately numbered, completely different sections of the VTL, and you cited the wrong one, otherwise everything else the same, would that still fit in then the like, or?
So I believe that that's more problematic than the situation that we have here, but I still think that if it's a VTL section 1192, 2, that you're changing to a 3 or to a 4, I think that that will be okay. I think it would be really problematic if we were adding a new charge or offense. For instance, we had a DWI count, and then we're doing something completely different.
And those wouldn't be all new charges if you changed 2 to 3 or 4 or something like that?
I don't believe so, no, because I think that
They're, never mind.
Well, why is that? Suppose the statute were structured differently, as the chief suggested, and you had different offenses, aggravated driving while intoxicated with a child passenger, and it was 2A, and then the second statutory provision, different provision of the BTL, was 2B. Why is the fact that it's in a subdivision dispositive of the analysis?
Well, because I think, as I stated, that because by violating any of those subdivisions, you violate the law. So I think that shows that it's clearly just a typographical error.
They're
that can be
completely
amended.
different ways of violating the law, right?
Sure, one is alcohol, one's drugs, and one is the combined influence of alcohol and drugs.
Would
But I
would an
still believe
indictment
that,
be sufficient if it said you violated the VTL by violating one of 2, 3, 4, or 4B without specifying which one?
yes, I believe that'd be fine, and then there'd be a bill of particulars that would correct that factual.
If there was only one count, only the first count, does that make a difference? I thought you were arguing in part the fact that all the other counts were about drugs made it obvious that it was a typographical error.
I don't think that would make a difference, because it wouldn't change the theory of the case, and it wouldn't prejudice the defendant whether or not we had actually charged. I mean, the other offenses were all misdemeanors. We could have made the choice to just charge the felony and go with that. We don't have to put all the counts in the indictment, so I don't think that would make a difference at all whatsoever, because the theory is the same and there's no prejudice to the defendant.
Are there some amendments to an indictment that would not be allowable even if they didn't prejudice the defendant and they didn't change the theory of the case?
Oh, absolutely. That's where
Yeah.
200.72 A and B come in. If it fails, a failure thereof to charge or state an offense, like in Perez, where we add a count, or the legal insufficiency of the factual allegations. If we do one of those two things with our amendment, then we have a problem, absolutely. So if there aren't any more questions, I would just like to state that this is the kind of minor typographical error that's subject to correction. The defendant had no surprise or prejudice. There was no lack of notice of the charges. It was clearly all along VTL 1192AB as charged in drugs under the second count. We merely corrected the subdivision contained within the statute itself as a typographical error. Thank you.
I don't think it was a typo. I think it was a mistake or an error. A typo is where you hit 0, instead of A. And we know from looking at the grand jury minutes.
But putting in Mercury instead of Ford is not exactly a typo either, but that, I thought you said would be okay. Changing the car from a Ford to a Mercury is not a typo.
But that's non-substantive. This is substantive. The substance is you have to say what the facts are. And by changing the fact is substantive, clearly. The other kind of errors, if we look at cases before this court or other courts, calling somebody Bobby instead of Robert, or having a wrong date or a wrong county. And in Perez, the court noted that a clerical error in an indictment with the wrong date was reversed because it was not one of form, it was one of substance. Substance means it makes a difference to the outcome. So a different name of a car, calling it a Ford Mountaineer instead of a Mercury, or a date, that's non-substantive. The law is the law here. If there is a policy issue here, that can be dealt with by the legislature. Perez has been the law of this state pursuant to this court's decision for over 30 years.
So if
And,
instead of saying subdivision 2, it said subdivision 13, and there's no subdivision 13, is that a typo, or it doesn't matter because it's still substantive?
Well, no, under the time, place, and form, it doesn't say stating the wrong statute or subdivision. That is not the kind of non-substantive change that the legislature considered. I can't find any case where citing the wrong subdivision has ever been allowed as a non-substantive change. Thank you.
Thank you.